The impact of this ruling quickly spread beyond the courtroom. 3 states that used similar voter verification tools announced reviews of their algorithms to check for hidden bias. The National Association of Secretaries of State established a working group on algorithmic transparency, tasked with creating best practices for any state relying on automated systems to manage voter rolls. Congress also responded. The House Administration Committee oversees federal election law, scheduled hearings on algorithmic transparency. Congresswoman Crockett was invited to testify not as an attorney in litigation, but in her role as a legislator. Her testimony shifted the focus away from the single case toward the broader structural challenge. The problem isn't just this one algorithm, Crockett explained. It's that our legal system hasn't kept up with the digital age. Algorithms can embed bias in ways traditional discovery rules simply don't catch. We need statutory requirements for algorithmic impact assessments before these systems are used in elections. We need clear standards for transparency that can't be dodged by clever technical design. Most of all, we must recognize that protecting civil rights in the digital era requires both legal expertise and technical expertise working together. Law schools immediately recognized the educational significance. Several leading institutions launched new courses on technical advocacy for civil rights, giving future lawyers the skills to evaluate algorithms, request the right data and discovery, and recognize when discrimination is being hidden behind code. The Crockett case study quickly became core teaching material in these programs. Civil rights organizations also began to adapt. Instead of depending solely on legal strategies, they started building litigation teams with technical experts from day one. The NAACP Legal Defense Fund even created a specialized algorithmic justice initiative to identify and challenge discriminatory, automated systems in voting rights cases. For Congresswoman Crockett, the case demonstrated something deeply personal, the power of combining law and technology to advance civil rights. In interviews months later, she reflected, "Technical systems are increasingly shaping decisions about fundamental rights. If advocates don't understand both the legal and the technical sides, they risk missing how discrimination is embedded in design." What this case showed is that technical understanding doesn't just provide evidence, it shapes legal strategy. Knowing what to request in discovery, spotting what's missing, and understanding how systems can conceal bias. These skills are now essential for civil rights enforcement. Even Judge Howell later acknowledged the lesson. Speaking at a judicial conference on technology, she carefully avoided case details, but reflected more broadly. This experience reminded me that judges must approach technical evidence with both skepticism and humility. We cannot assume our first instincts are correct when facing complex systems. Most importantly, judiciary has a duty to ensure that technological complexity never becomes a shield against accountability that requires ongoing judicial education and serious attention to expert testimony, especially in cases affecting fundamental rights. 1 year after that dramatic hearing, the ripple effects were clear. The state replaced its voter verification program with a new system that included public algorithmic impact assessments and regular bias audits. Thousands of improperly purged voters were restored to the rolls. Most importantly, the Department of Justice implemented new national requirements mandating full algorithmic transparency in voting rights litigation, ensuring such concealment could never happen again. Legal commentators summed it up best. Some of the most important developments in civil rights don't come from Supreme Court rulings, from moments when determined advocates expose injustices that might otherwise stay hidden. The day Congresswoman Crockett wiped the smile off Judge Howell's face with undeniable evidence was one of those moments. It reshaped not only a single case, but the way our system confronts algorithmic discrimination in voting rights. If this story of technical evidence overcoming judicial doubt inspired you, don't forget to like this video and subscribe to our channel. Share it with someone interested in how modern civil rights advocacy requires both legal insight and technical expertise. The fight for algorithmic justice continues, and we'll be here covering the moments that matter. Inside the overflowing courtroom, the atmosphere was electric. Civil rights advocates filled the benches. Election administrators and technology specialists leaned in to listen closely, and law students scribbled notes for what their professors promised would be a landmark case study at the crossroads of technology, democracy, and judicial review from the start. Judge Howell's tone was skeptical. Her questioning of Crockett's counsel had been sharp and often dismissive, framing the motion as little more than a fishing expedition. Many observers expected her to shut down Crockett, just as she had done with countless attorneys before. But when Crockett herself rose to deliver her argument, the dynamic began to shift in ways nobody in the room had anticipated. "Your Honor," Crockett began with deliberate calm, Our request isn't based on speculation. We have concrete technical indicators that show key algorithm documentation is still missing. Howell's expression hardened as she cut in. Congresswoman Crockett, the government has certified it has produced all relevant records. What proof do you have to say otherwise? Instead of diving straight into legal jargon, Crockett surprised the entire courtroom with a strategy no one had seen coming. If I may. Your Honor, Crockett began carefully. I'd like to start from a technical angle. The partial code we've received contains reference calls to outside modules that weren't included in the government's production. These missing modules appear to house the weighting factors used to decide which voters were flagged for removal. For the first time, Judge Howell leaned forward slightly. Unlike many federal judges, she had a strong background in digital evidence and cybersecurity from her years before joining the bench. That experience gave her a deeper technical perspective on arguments like this, even if those modules exist. Counselor, Howell interjected, what proof do you have that they're discriminatory? Technical systems reference external libraries all the time. That's not evidence of concealment. Crockett nodded, acknowledging the point. You're absolutely correct, Your Honor. Most systems do call external libraries, but in this case, identified specific API calls to a module labeled demographic under relator that the government hasn't produced. And within those calls, we found variable names like races oxy and ethnic indicator that strongly suggests these factors were being considered in the purge algorithm. Howell's expression changed, no longer dismissive, but curious. Those names are interesting, Congresswoman. But names alone don't prove how the system functioned. Developers often use sloppy or misleading naming conventions. I agree with you completely, Crockett replied smoothly, building on the judge's skepticism instead of resisting it. Variable names by themselves wouldn't justify our motion, but we also uncovered log files showing that 83.6% of the voters flagged for removal lived in predominantly minority census blocks. Even though those blocks only make up 24.2% of the state's population, that extreme disparity is what led us to dig deeper. Judge Howell frowned. Disparities don't automatically prove intentional discrimination. Congresswoman, there could be legitimate explanations for those numbers. That's exactly why we need the missing modules, Your Honor, Crockett countered. Without them, we can't determine whether lawful factors or unlawful ones produce those results. At that moment, DOJ Attorney Sarah Jenkins rose from her seat. Your Honor, the government has already certified that it turned over all relevant documentation. Counsel's claims about missing modules are pure speculation without any foundation. Howell nodded, seeming to agree. Ms. Jenkins makes a fair point. Congresswoman, you're asking this court to compel production of files the government swears don't exist or aren't relevant. What actual evidence do you have that challenges their certification? This was the pivotal moment. Crockett paused, measuring her words. Your Honor, we believe the government's certification is at minimum incomplete. Her calm delivery contrasted with the gravity of her claim. In federal court, even hinting that DOJ attorneys had missiled the bench was extraordinary. Howell's eyes narrowed. That is a serious allegation, Congresswoman. Are you accusing the Department of Justice of making false statements to this court? I'm not accusing anyone of bad faith, Crockett clarified. What I'm saying is that there's a clear gap between what the government says it has produced and what outside evidence shows exists. That gap cannot be ignored. The judge's skepticism sharpened. And your evidence for this? Crockett's voice stayed steady. 3 indicators, Your Honor. First, unexplained code references we already discussed. Second, a FOIA response from another federal agency that explicitly mentions the demographic under relator module, proving it exists. And third and most important, emails between developers discussing the need to move demographic weighting factors into an external module for compliance purposes. This last point drew a visible reaction from Judge Howell. You have emails referencing deliberate separation of demographic data. Why didn't you include those in your initial filing? Because we only obtained them yesterday through a public records request, Crockett answered. They were not part of the government's discovery production, even though they clearly fall within our request. Jenkins immediately jumped back to her feet. Your Honor, the government has no knowledge of these so-called emails. Without reviewing them, we can't respond to counsel's description. Judge Howell turned back toward Crockett. Do you have these emails with you, Congresswoman? Yes, Your Honor, Crockett said, reaching toward her briefcase. Then she paused. Before I hand them over, I want to be clear. Our intention isn't to embarrass the Department of Justice. Our only goal is to ensure full discovery of the algorithmic components directly tied to our claims. Howell's patience was wearing thin. Let's see these emails, Counselor. It was in that very moment, right before Crockett unveiled the records, that she made an assertion so bold, so unlikely that Judge Howell herself broke into laughter. Your Honor, Crockett said steadily, these emails indicate that certain modules were deliberately excluded from discovery in this case, and others like it to block any examination of how demographic factors influenced voter purge decisions. Though that was the moment Judge Howell laughed. A short, sharp chuckle that broke the seriousness of her courtroom and violated typical judicial decorum. With a smirk, she said, Counselor, that sounds like a conspiracy theory. The government doesn't hide evidence. Discovery rules exist for a reason. The laugh was brief but unforgettable. It was a clear message that the judge viewed Crockett's claim not just as weak, but ridiculous. Ridiculous enough to crack her normally controlled demeanor. The courtroom went silent. Dozens of eyes turned toward Congresswoman Jasmine Crockett, who stood perfectly still at the podium, her face calm and unwavering in the face of the judge's dismissal. Your Honor, Crockett replied evenly, I'd like to present Exhibit C. From her briefcase, she pulled a manila folder and handed it to the court clerk. Judge Howell began flipping through the contents, and the transformation was immediate. The dismissive smile vanished. Her brows furrowed as she scanned page after page, sometimes rereading a line as disbelief spread across her face. The entire courtroom sat frozen in silence. Every turn of the page built more tension. After only 2 minutes, though it felt much longer, Judge Howell looked up sharply at the DOJ attorney. Miss Jenkins, are you familiar with these communications? The government lawyer looked genuinely baffled. No, Your Honor. As I stated earlier, we have no knowledge of these emails. The judge's voice was suddenly serious, stripped of all sarcasm. These appear to be internal communications between the developers of the voter verification system and legal counsel. They explicitly discuss quoting directly segregating demographic weighting factors into standalone modules that would not be included in standard discovery productions. She flipped another page here. Another email refers to maintaining technical deniability about the race correlator algorithm. The DOJ attorney's face drained of color. Your Honor, this is the first I'm hearing of these communications. The department would never condone. Ms. Jenkins, Howell interrupted, her voice cutting like steel. I understand that you personally may not have known, but these emails use government domains. Several recipients are attorneys within your own department. Turning back toward Crockett, the judge's tone had completely shifted. Congresswoman, when and how did you obtain these documents? Through a state-level public records request to the Secretary of State's IT department, Crockett explained. They were produced just yesterday. It appears state employees weren't aware these communications had been withheld from the federal discovery production. Judge Howell picked up another sheet from the folder. Her expression darkened. This email refers to creating, and I quote, alternate documentation for litigation purposes, omitting any mention of the demographic correlator. Congresswoman, do you believe this so-called alternate documentation is what was given to you in discovery? Yes, Your Honor, Crockett answered without hesitation. The file checksums in these emails match exactly with the discovery files provided to us. Those checksums differ from the original technical specifications referenced elsewhere in the chain. The judge slowly removed her glasses, gesture familiar to attorneys who knew it signaled deep concern. Setting the documents down, she said firmly, the court will take a 15-minute recess. Miss Jenkins, you are to contact your supervisors immediately. Congresswoman Crockett, I will need authenticated copies for the record. As Judge Howell rose from the bench, the shift in atmosphere was unmistakable. The laughter and dismissiveness were gone. Her expression was grave, reflecting the weight of potential discovery misconduct now looming over the case. When court reconvened, the tone was completely different. Judge Howell's words were measured, unmistakably serious. Based on my preliminary review of Exhibit C, I have substantial concerns about the completeness of the government's discovery productions. These communications strongly suggest the deliberate withholding of technical documentation central to the plaintiff's discrimination claims. Her gaze locked on the DOJ attorney. Miss Jenkins, I understand you've consulted with your supervisors. What is the government's position on these documents? The attorney stood visibly shaken. Your Honor, the department takes this matter extremely seriously. We've begun an internal review to determine how such communications could have been omitted. Until that review is complete, we cannot comment on their authenticity or context. That's not enough, counsel. Howell shot back firmly. These records don't suggest oversight. They suggest intentional concealment. Does the government dispute their authenticity? We cannot confirm or deny authenticity at this time, Your Honor. We need to review how I'll cut her off. Her patience gone. I'm not asking for a full investigation right now. I'm asking whether you have any immediate basis to dispute the authenticity of emails sent to and from government domains, discussing government systems with government attorneys included in the chain. The attorney hesitated. No immediate basis, Your Honor. Then the court will proceed on the presumption that these emails are authentic unless proven otherwise. Howell said flatly, turning back to Crockett. Judge Howell leaned forward slightly. Congresswoman, what specific relief are you requesting in light of these disclosures? Remaining calm and solution-focused, Crockett responded with precision. Your Honor, we ask for 3 remedies. First, the immediate production of all modules referenced in these emails, particularly the demographic correlator module. Second, permission to depose the individuals identified in these communications to understand the full algorithm architecture. Third, in light of the clear attempt to withhold critical evidence, we request the court appoint an independent technical expert to review the system for discriminatory features. Judge Howell considered the request carefully, then nodded. Those requests appear reasonable under the circumstances. Turning to the government's attorney, she asked, Ms. Jenkins, do you require time to respond? Yes, Your Honor, Jenkins replied nervously. Given the seriousness of these allegations, 14 days to investigate and prepare a response. The judge's expression showed immediate disapproval. 14 days is far too long. The government will have 3 business days to verify the existence of these modules and begin producing them. Regarding the independent technical expert, I am inclined to grant that immediately. Her voice was firm and deliberate. Let me make this absolutely clear to all parties. This court takes discovery obligations with the highest seriousness. If there has been intentional withholding of evidence, those responsible will face significant consequences. Turning back toward Crockett, Judge Howell's tone softened slightly. Congresswoman, the court appreciates your diligence in pursuing this matter. Your technical knowledge and persistence have brought to light what appears to be a significant discovery failure, something that might otherwise have gone unchallenged. It was a striking reversal. Just minutes earlier, Judge Howell had laughed at Crockett's claims. Now she was openly acknowledging the Congresswoman's expertise and the importance of her evidence. Observers in the courtroom understood they were witnessing something remarkable. A federal judge fundamentally changing course in real time, persuaded by evidence that could no longer be dismissed. The impact stretched beyond that single hearing. What began as a routine discovery dispute had grown into a profound debate about transparency, accountability, and the role of algorithms in voting rights cases. By the next morning, Judge Howell issued a formal written order that expanded on her bench rulings. The order appointed Dr. Elenina Chen, a nationally respected computer scientist known for her work on algorithmic bias, as the court's independent expert. It also mandated preservation of all communications tied to the voter verification system and scheduled a full evidentiary hearing on the apparent discovery violations. Most striking of all, the order contained an unusual acknowledgement. The court notes that but for counsel's technical expertise and diligent investigation, the apparent concealment of algorithmic components may have succeeded, potentially preventing plaintiffs from proving their claims regardless of merit. This recognition sent shock waves through the legal community. The National Law Journal quickly ran a headline piece titled Technical Expertise Meets Legal Advocacy. How Congresswoman Crockett exposed algorithmic concealment. Law schools with technology clinics began citing the case as a model of why technical literacy is now essential for effective civil rights advocacy. Within days, the Department of Justice announced a sweeping internal review to understand how such critical algorithmic documents had been omitted from discovery. The Inspector General launched an investigation across all pending voting rights cases to ensure no similar concealments had occurred. Several DOJ attorneys involved in voting rights litigation were placed under review. The DOJ's Civil Rights Division then issued updated discovery guidance. The memo stated clearly, all components of systems used for voter roll maintenance must be disclosed in discovery, including any modules or code that process or analyze demographic data, regardless of how such components are structured or labeled. Legal technology experts quickly recognized the broader implications. Stanford law professor Jennifer Martinez commented, "This case shows how traditional discovery procedures often fail when algorithms are involved. Technical systems can be designed in ways that hide discriminatory features, making specialized expertise essential for enforcing civil rights laws effectively." 2 weeks later, Dr. Chan submitted her preliminary expert report. While filed under seal, the court released a public summary. Her findings confirmed what Crockett had suspected all along. The so-called demographic uncorrelated module embedded in the system contained weighting factors that disproportionately targeted minority voters for removal. The report revealed the algorithm assigned higher removal scores to individuals with naming patterns common in certain racial and ethnic groups, and to voters who had moved between minority neighborhoods. These variables were not labeled explicitly by race, but functioned as proxies that produced racially disparate outcomes. Dr. Chan's findings transformed the entire case. What had started as a discovery dispute now evolved into substantive evidence of discriminatory practices, evidence that could shape the future of voting rights enforcement nationwide. Judge Howell soon issued a preliminary injunction stopping the voter purge program in its tracks. She also ordered the reinstatement of voters who had already been removed through the algorithm. In her written opinion, she directly cited Crockett's technical analysis, noting, as correctly identified by plaintiff's counsel, the algorithm structure deliberately separated neutral-appearing functions from hidden modules containing proxy variables tied to race and ethnicity. This architecture seems designed not only to disguise the system's discriminatory effects, but potentially its discriminatory intent as well. The courtroom of the U.S. District Court for the District of Columbia was packed and tense. A hush fell over the room, though the sound of Judge Beryl Howell's dismissive laugh still seemed to linger against the polished mahogany walls. All attention turned toward Congresswoman Jasmine Crockett, standing tall at the podium, her face calm and unshaken. Just moments earlier, Judge Howell, former chief judge of one of the nation's most powerful federal courts, had openly laughed at Crockett's claim that the government was concealing critical evidence in a nationally significant voting rights case. Counselor Howell had remarked with a smirk, "That sounds like a conspiracy theory. The government doesn't hide evidence. We have discovery rules for that." The short burst of laughter that followed wasn't just casual. It broke courtroom decorum and sent a loud signal that she considered Crockett's argument not only weak, laughable. For many, that laugh suggested the case was already over. But Crockett didn't flinch. Instead, she calmly reached into her briefcase and pulled out a single manila folder. "Your Honor," she said in a steady voice, "I'd like to submit Exhibit C." What happened next stunned the courtroom. Within minutes, Judge Howell's mocking confidence was gone. She halted the proceedings and announced an immediate recess, visibly shaken by the evidence Crockett had introduced. The moment marked a dramatic turning point, not only in the case, but in Howell's reputation as a judge who prided herself on controlling her. Courtroom. Before revealing the contents of Crockett's folder, make sure you hit the subscribe button and tap the notification bell. We bring you the most powerful courtroom showdowns, moments the mainstream media ignores, where the stakes are nothing less than democracy itself. The case in front of Judge Howell was no ordinary legal fight. At issue was a controversial voter roll purge that threatened to strip thousands of citizens of their right to vote. Civil rights groups alleged that the purge relied on racially biased algorithms that disproportionately targeted minority voters. State officials flatly denied the claim, insisting the purge was lawful and neutral. Meanwhile, the Department of Justice had stepped in to support the state, arguing there was no proof of intentional discrimination or disparate impact. Judge Beryl Howell carried enormous weight in this proceeding. To the federal bench by President Obama in 2010, she later served as chief judge of the D.C. District Court from 2016 to 2023. Her background was equally impressive, a career that included serving as a federal prosecutor, Senate Judiciary Committee counsel, and private practice litigator specializing in complex cases and digital evidence. Known for her razor-sharp intellect, efficiency, and intolerance for unfounded claims, Howell had long been respected across political lines. Her courtroom reputation was clear. She demanded precision, valued order, and had little patience for arguments she deemed speculative. What do you think about how states maintain voter rolls? Are current voting systems transparent enough to balance election security with fair access to the ballot? Share your thoughts in the comments below. We value your voice in this debate. On the opposite side of the courtroom stood Congresswoman Jasmine Crockett, bringing with her an entirely different kind of authority. Before her election to Congress, representing Texas's 30th District, Crockett built her career as a fierce civil rights attorney. Her specialty was voting rights and election law, and she had successfully challenged multiple voter suppression laws across the country. She was known for her ability to translate complex technical evidence, statistical data, algorithms, and digital systems into clear, compelling courtroom arguments. Though now serving in Congress, Crockett had gained special approval to represent the civil rights groups, in this case Pruno, calling it a fight too important to ignore. Her decision drew mixed reactions. Critics claimed her dual role as legislator and lawyer blurred ethical lines, while supporters praised her commitment to protecting democracy from both the legislative and legal fronts. That day, the legal battle centered on discovery. Crockett's team had filed a motion to compel production of algorithmic data tied to the purge, arguing they could not expose discriminatory practices without access to the system's technical records. State officials and DOJ attorneys pushed back, saying every relevant document had already been turned over.